Okay, it is 12 noon here on the East Coast, and for those of you tuning in elsewhere, it is the top of the hour, we presume, wherever you are. So thank you for taking the time to be with us. This is my first program back with you in a couple of weeks. I'm hopeful that you've enjoyed the end of summer, not officially, but in all other measures, and that for those getting back into the swing of things with kids in school and the like, that it's been going as well as possible, and that everyone enjoyed a good Labor Day. Here in New York City, it is beautiful today. It is that period just before it gets noticeably cold and everyone needs to start wearing jackets. But it's also definitely not as hot as it has been at times during the summer. And lots of people are walking about, and it's a good time to be here if anyone wishes to come on and make a visit through. We are here, of course, though, to talk about what's on the agenda for the webinar. There is plenty happening in the world of law and policy, and I look forward to walking you through what we will be covering. So if Sophie, you'd please advance to the next slide, I'll go and tell everybody about the agenda. Actually, the one after that, please, would be great. Thank you. And so right after I'm done with these opening remarks, Kamisha Parkins will be presenting. She's here in the New York City office, and literally in my office, actually, because of a little technical issue on our side. But the good news is that we are able to make sure that you are able to hear from Kamisha, and she'll immediately follow me. And what she'll be covering, as someone who is known to all of you and a regular presenter on the webinar, she'll be addressing a new law that the Governor Hochul has signed concerning violence prevention. Has interesting implications for the workplace, and we wanted to make sure that all of you were absorbing it and understanding what it's about. And then after that, we have three other attorneys who are joining us for the first time on the webinar. First, we'll have Christy Weglars from our Melville office, and Christy will be here to talk about the Corporate Transparency Act. We've presented on that to you before, but we wanted to remind you of upcoming deadlines, and there are things about this which you can never hear too much about because it's new, and we want to ensure that it's on everyone's radars. We're here as well to help. And then after that, we'll be hearing from Sam Nice, who is with us from our Garden City office, and she will be tackling a case involving whether they're standing for technical violations in the labor and employment context. She'll tell you more about it, but it's a case that we learned about through leaders of the labor practice in our Syracuse office, and we want to make sure that we summarized it for you all, and Sam has graciously offered to do that. After that, Alyssa Christian will be with us. Alyssa is with us specifically from Syracuse, and Alyssa will be covering the FTC and its recent announcement concerning bans on fake reviews and otherwise faulty testimonials. It's worthwhile news that we think will apply to lots of you, and we wanted to make sure that you had a chance to hear about it.
My name is Christy Weglars. I'm an associate in the firm's business group. So like Gabe said, today I'll be discussing the Corporate Transparency Act and the upcoming January 1st, 2025 deadline. If you could just move to the next slide, please. So the goal of the CTA is to create more transparency and to prevent shell companies from hiding illegal activities, including money laundering, financing terrorism, and other activities. So reporting companies must submit BOI reports to FinCEN, and the deadline for filing vary depending on when the entity was formed or registered to do business in the US. So if the entity was formed before January 1st, 2024, the company will need to file a BOI report by January 1st, 2025. If formed in 2024, companies have 90 days from formation or registration in the US to file. So if the company was formed on or after January 1st, companies will have only 30 days from formation or registration in the US. So what type of entities does the CTA apply to? So the CTA applies to entities created by filing formation documents with a Secretary of State or a similar office in the US. So for example, corporations and LLCs and limited partnerships. The CTA also applies to foreign entities registered to do business in the US. Certain entities are exempt from filing, which I'll get to later on in the presentation. Next slide, please, Sophie. Okay, so what needs to be reported? So reporting companies must disclose, the legal name of the company, its business address, EIN number, if it has any trade names, as well as its state of formation or registration. They'll also need to disclose the company's beneficial owners. So a beneficial owner is any individual who directly or indirectly has substantial control over the company, or who owns or controls 25% or more of the ownership interest in the company. So individuals may have substantial control over a company in different ways. So for example, a senior officer such as a president or a CEO, or other officers performing a similar function. Also, individuals with power to appoint or remove senior officers, or to remove majority of the board of directors. Substantial control also extends to persons having important decision-making control, as well as a catch-all. So there's the catch-all that includes, anybody who may have substantial control over the company. So when it comes to the beneficial owners, you must report the full legal name of the individual, their date of birth, their residence address, as well as personal identification number that would be found on a passport or a driver's license. And you must also upload an image of a driver's license or a passport. So FinCEN provides the option to apply for a FinCEN ID, which is an identification number that helps you file reports easier instead of having to upload, your full name and the image of your passport or license. You can apply for a FinCEN ID in advance to make that process easier. A FinCEN ID is also helpful because if you ever had to change your information, you can just change it in connection with your FinCEN ID, as opposed to having to go back and make amendments to any BOI reports. Next slide, please. So the company applicant, this information is only applicable to companies formed in 2024 or after. So the company applicant can be up to 2 individuals. It can be the person who physically files the formation documents and the person who oversees or directs the filing, if that's a different person. So an example of that would be if an attorney instructs her paralegal to file the LLC's formation documents, then both the attorney and the paralegal would be company applicants and they would need to be disclosed. So the company applicant is not applicable to companies formed prior to 2024. Next slide, please. So as I mentioned earlier, there are 23 different types of exemptions. If a company meets the specific requirements for a particular exemption, then the company would be exempt from filing a BOI report. So exemptions mainly include types of companies that are already subject to significant regulatory oversight, or they pose a low risk of being used for illegal activities. So this chart here shows the 23 different exemptions. Each one has specific qualifying criteria. One of the exemptions that we receive a lot of questions about is the inactive entity exemption. So a lot of clients have entities that they formed, but they never used or intended to dissolve, and they never got around to it. So to qualify for that exemption, 6 requirements must be met. The entity must have been formed before January 1st, 2020. The entity must not be engaged in any business, any active business. The entity must not be owned directly or indirectly by a foreign person. There must have been no change in the ownership in the last 12 months, and the entity must not have sent or received funds greater than $1,000 in the last 12 months, and must not hold any assets, including interests in other entities. Another exemption that a lot of our clients fit within is the large operating company exemption. So to qualify for that exemption, the entity must employ more than 20 full-time employees in the US. They must have filed a federal income tax return in the previous year, showing more than $5 million in gross receipts or sales, and the entity must have an operating presence at a physical office in the US. Keep in mind that if any entity's exemption status changes, then a company would need to file a BOI report. Next slide, please. So preparing for 2025, January 1st is only a few months away. So keep in mind that any non-exempt entities formed prior to 2024 must file an initial BOI report no later than January 1st, 2025. Also keep in mind that new entities formed in 2025 and after, they'll only have 30 days to file as opposed to 90 days, as is the case now. Some of the common questions that we received with respect to the CTA are there any filing fees? No, CTA, FinCEN does not charge any kind of filing fee to file a BOI report. Other questions are, is this an annual filing? No, BOI reports are a one-time filing. However, if there are any amendments needed, for example, the company registers a DBA, or your beneficial owners change, or any of the other information reported, a change would need to be filed within 30 days of that change. So FinCEN's website has a lot of helpful information on the CTA, including a small entity compliance guide and answers to frequently asked questions. Also, feel free to reach out to the firm with any questions or email me as well. Thank you.
Hi, this is Gabe back. Christy, you did a wonderful job at stepping in and covering the really important material of the CTA. Christy, as you said, we are available as a firm to help any entity that isn't quite sure about how to get its arms around this requirement. And Christy is a great point of contact, as are many other attorneys who are involved in the work. So Christy, thank you for your debut. Didn't mean to have it start in such a bumpy way, but so glad that you were able to step in and help to cover for us when we had a technical glitch on our side. So if all will allow it, we'll actually go backward and we'll try now to complete Kamisha's presentation. So if Sophie, you could go to the first presenter slide, that would be great. And Kamisha will be here now to conclude her remarks. Kamisha?
Thank you, Gabe. And thank you all for your patience. Okay. So as I was discussing before, Governor Hochul on September 5th, 2024 signed the Retail Worker Safety Act into law, which requires certain New York retailers to adopt safety measures to both prevent and address workplace violence in retail settings. This new legislation amends the New York labor law, and it imposes requirements intended to protect retail workers at a wide range of small businesses as well as large-scale retailers. Most of the law's provisions will go into effect in March of 2025, which is about 180 days from the day that the law was enacted. And other requirements within the law will be taking effect later, which I will discuss later. I will discuss some of the more notable requirements that employers should certainly be aware of. So first, who's covered? Covered employers, as the law states, include any person, entity, business, corporation, partnership, limited liability company, or an association employing at least 10 retail employees. These retail employees must work in a retail store specifically that sells consumer commodities. Now, I'm sure that the Department of Labor will be releasing a guidance document to explain further what exactly consumer commodities includes. So once that is released, we will sure be providing that update. The law also specifies that retailers who primarily sell food for consumption on the premises are excluded. Additionally, employees of the state, any political subdivision of the state, a public authority, or any other governmental agency or instrumentality are also excluded from coverage under the Act. So what's required under this Act? First, the covered retail employers are required to adopt a workplace violence prevention policy. I know that's a lot, a workplace violence prevention policy. The law specifies that at a minimum, the policy should outline a list of factors or situations in the workplace that might place retail employees at risk of workplace violence, including but not limited to working late nights or early mornings, exchanging money with the public, working alone in small numbers, and uncontrolled access to the workplace. The policy must also outline methods that the employer may use to prevent incidents of workplace violence, including but not limited to establishing and implementing reporting systems for incidents of workplace violence. The policy must also include information concerning the federal and state statutory provisions concerning violence against retail workers and remedies available to victims of violence in the workplace, and a statement that there may be applicable local laws. And the policy must also clearly state that retaliation against individuals who complain of workplace violence or the presence of factors or situations in the workplace that might place retail employees at risk of workplace violence or who testify to assist in any proceeding under law is explicitly unlawful. I do want to note that the law provides that the Department of Labor will post a model policy for employers to utilize on the department's website. However, right now it is unclear when the model policy will be released, but we will be providing that update once it becomes available. Details are certainly forthcoming. Employers must also, by March of 2025, establish an interactive workplace violence prevention training program that includes, at a minimum, information on the requirements under this act, examples of measures retail employees can use to protect themselves when faced with workplace violence from customers or even other coworkers, de-escalation tactics, active shooter drills, emergency procedures, instructions on the use of security alarms and panic buttons and other related emergency devices. This training program must also provide information addressing conduct by supervisors and any additional responsibilities for such supervisors, including ways to address workplace-specific emergency procedures. And the training program must also provide training on areas of previous security problems. As part of this training, every employer must communicate to each employee a site-specific list of emergency exits and meeting places in the case of an emergency. Again, the Department of Labor will be providing a model workplace violence prevention training program that employers may adopt and tailor to their specific workplaces. The model training program will likely be posted at the same time as the model workplace prevention policy. And so employers should look out for both items once they are released. In addition to both the training program and the policy, retail employers, effective January 1st of 2027, will need to provide access to panic buttons throughout their workplace. Now, I do want to make sure I specify that this only applies to employers with retail employees of 500 or more. 500 or more. So when you're thinking of these types of employers, you're thinking of Target and Walmart and other large scale retailers. So these specific retailers will be required to provide access to panic buttons throughout the workplace. And the act defines panic buttons as a physical button that, when pressed immediately, contacts the local 911 public safety answering point and provides that PSAP, which is the public safety answering point, with employee location information and dispatches local law enforcement to the workplace. these specific employers may install panic buttons in an easily accessible location in the workplace, or they may provide all employees with wearable or mobile phone-based buttons, which may only be installed on employer-provided equipment. And they obviously cannot be used to track employee locations as well. Finally, the Act provides the employers with requirements related to notice. And these requirements begin March of 2025. So covered retail employers will be required to provide the following to all employees upon hire and then annually thereafter. These employers will have to provide a copy of their written workplace violence prevention plans, a site-specific list of emergency exits and meeting places in case of emergency, and also a notice. And this notice must be in writing, in English, and in the language identified by each employee as their primary language. So it will need to be in English and in other languages if necessary. And it will also have to contain the employee's retail workplace violence prevention policy, as well as information presented at the workplace violence prevention training program. So those are many of the notable requirements as part of the Retail Worker Safety Act. We are actively tracking this law for any new developments, and we'll be sure to report them on the webinar as well as in our alerts as they arise. Thank you all.
And let me say thank you, Kamisha, for covering that topic so fully and capably. And you're always welcome back on the program. We thank you for your time. And let me also note for all of you that I'm supervising Kamisha's presentation today. Her last day as an associate trainee. She won't need that supervision going forward. Now, if we may, let's turn, as had been originally planned, to Sam Nice's presentation. And Sam is with us for, as noted, the first time on the program. We're delighted to have Sam and representing the Garden City office specifically today. And Sam is here to talk about this holding concerning standing and technical violations. I'd love for you, Sam, to get into the details of it so that we can all better understand why this is important. And thank you so much in advance for taking the time to cover this topic.
Of course. Hi, everyone. As Gabe said, I'm Sam Nice, and I'm going to be presenting today on courts indicating that there's no standing for technical violations under New York labor law for an employee's failure to provide wage notices and wage statements to employees. So I'm just going to start by briefly explaining what the New York labor law requires, possible damages that could be recovered by employees if an employer commits a technical violation of the labor law, and then reviewing some recent decisions that bode well for employers, including a Second Circuit decision issued on August 30th, as Gabe alluded to, and then ultimately summarizing where that leaves us. So if you go to the next slide, Sophie, that would be great. So the New York State Wage Theft Protection Act, which I will be referring to as the Wage Act, took effect on April 9th, 2011. And this act requires employers to give written wage notices to employees upon hiring them, which employees must date and sign. The wage notice must include the employee's rate or rates of pay, including any overtime rate of pay, how they will be paid, so by the hour, by the day, their regular payday, the official name of the employer, the address and telephone number of the employer's main office, and any allowances taken as part of the minimum wage. So tips, meals and lodging deductions, so on. These notices must be given in English and in the employee's primary language if it's not English. And if any data in the notice changes at any point, the employer must tell employees at least a week before it happens, unless they issue a new pay stub that carries this information. And the employer must also notify an employee in writing before reducing or raising the employee's wage. Sample pay notices are found on the Department of Labor's website, but an employer can just create their own so long as it includes all of this previously mentioned information.
The Wage Act goes further to require employers to provide employees with wage statements each payday. So these statements must include much of the same information in the wage notice, but also must include something like an employee's gross and net wages, itemized deduction, the dates of work covered by the payment, and so on. And the employer must give any employee who asks for it a written explanation of how they computed their wages. Sophie, if you could go to the next slide, that would be great. So the statute explains that failure to comply with it can lead to hefty civil claims and fines, and these can add up quickly. Specifically, if employers do not provide their employees with a wage notice within 10 days of the date of hire, they face damages of up to $50 per day that the violation occurred, capped at $5,000 per employee. And similarly, an employee who doesn't receive compliant wage statements can recover up to $250 per day, again, capped at $5,000 per employee. So you can see that mere technical violations of the Wage Act alone can lead to damages of up to $10,000 per employee, not even including reasonable attorney's fees, which could also potentially be recovered. So with that being said, it seems abundantly clear that employers would not want to make such violations. However, on the next slide, Judge Pamela Chen of the U.S. District Court of the Eastern District has issued a string of 3 decisions on consecutive days in March 2022, which make it more challenging for plaintiffs to recover damages for technical violations of the law. And these decisions bode very well for employers. Before getting into these decisions, I just want to emphasize that the Wage Act is a New York state law with no federal equivalent, but because federal and state wage laws often overlap in other areas, employees suing employers in New York for improper payment of wages often sue in federal court and assert both claims. So on the next slide, you'll see the first of these 3 decisions, which is Francisco v. New York Tax Care Incorporated. Their plaintiff brought a putative class action against defendant employer, alleging that defendant employer failed to provide employees with wage and hour notices upon hire or when they received raises, which is also required, and that wage statements for each pay period did not include the necessary information. Judge Chen held that while those may be technical violations of the labor law, neither plaintiff nor the record was able to demonstrate that these technical violations actually led to a tangible injury or something akin to a traditional cause of action. And the Supreme Court has made it clear that a statutory violation alone without such tangible injury does not constitute an injury that can be recognized by the federal courts. And in making this decision, Judge Chen cited to TransUnion LLC v. Ramirez, which is a 2021 Supreme Court decision. So ultimately, plaintiff lacks standing to bring these claims. On the next slide, you'll see the second decision in this string, which was Wang v. XBB. This is pretty much analogous. Their plaintiff alleged, among other things, that defendants failed to provide her with these requisite wage notices. And Judge Chen here was like, you know what? You did establish by preponderance these violations, but nonetheless, you lack standing because it's not clear that the failure to provide these notices led to an actual injury that you suffered. So in other words, there was no actual injury felt by plaintiff for simply not receiving this notice, right? She wasn't paid any less as a result of not having received this notice. She just didn't receive it. It didn't bring her any harm or affect her in any way. And as mentioned in Francisco, technical statutory violations like this one that don't actually lead to a tangible injury can't confer Article 3 standing in federal court. On the next slide is the third decision in this string, Sevilla versus House of Salads, 1 LLC. Again, group of employees brought claims on behalf of a putative class, alleging that their employer failed to provide the required wage notice and wage statements. And again, Judge Chen agreed these technical violations had occurred, but using the same reasoning. And used the same reasoning. She explained that these employees lacked Article 3 standing to maintain these claims. So that brings us to the recent decision on the next slide. Guthrie v. Rainbow Fencing Incorporated, where the Second Circuit also used this TransUnion logic that Judge Chen was using to find a lack of standing to assert Wage Act violations. Plaintiff argued that he had standing because he had suffered an informational injury. Well, that was sufficient. He believed an informational injury was sufficient harm to have standing. So basically, he alleged he had standing because his employer omitted information that the Wage Act required him to have required the employer to provide employees with, which could, for example, cause an employee to be unable to apply for public benefits because they lack the proper documentation or something like that. And the court ultimately rejected this argument and found that this plaintiff also lacked Article 3 standing because while an employee could in fact face this hypothetical injury that the plaintiff is alleging, he did not link any concrete injury, in fact, to his employer's lack of providing him with these wage notices and wage statements. This hypothetical scenario that he concocted it could have happened, but it did not actually happen to him. And an employee is not simply injured because information it was statutorily supposed to receive was not given to them. So ultimately, this reiterates that pleading a mere technical violation or failure is not sufficient to establish standing. Employees asserting Wage Act claims in federal court must allege a concrete injury in fact. So where does this leave us? On the next slide, thank you. So given these decisions, a cautious employee may be more likely to bring these claims in New York State court rather than federal court and on an individual basis as opposed to in a putative class action because of the difficulty in achieving standing in federal court. But it's important to emphasize that the Second Circuit did not entirely close the door on hearing Wage Act cases. It didn't rule that Wage Act claims could never be brought in federal court. There is in fact a situation where such a case could satisfy the standing requirement and be heard in federal court. For example, the case cited is Marine. It's another Eastern District decision where the defendants violated the wage notice and statement statute willfully to intentionally disguise the number of hours plaintiff and other individuals worked and to avoid paying them for the full hours that they worked. And no lack of Article 3 standing was found here. They had standing. So if an employee has suffered an actual concrete injury, such as being paid less because their employer didn't comply with the Wage Act, they can have standing to bring a case like this in federal court. That is all I have. Thank you all very much.
And Sam, thank you for that really informative presentation. And we are thrilled to have you back on any program that you can join for if you have new information, whether on this line of cases or otherwise. And most importantly, thank you for taking the time. And we look forward to, again, hearing from you in a future instance. Let me turn to the last of our presenters for this webinar. And that is, as noted, a new presenter from the Syracuse office. It's Alyssa Christian. We're delighted to have Alyssa with us. Alyssa was asking me about what might be a good topic to present on, and we came to this FTC announcement, which we thought was very timely and otherwise relevant to many of you. And so, Alyssa, I'll let you take it away. There are all kinds of implications around fake reviews, whether the FTC has something to say about it or otherwise, but that a major federal agency is opining, we thought was certainly worth an update. So please go right ahead, and thank you so much for recommending this topic.
Thank you, Gabe. So last month, the Federal Trade Commission, or the FTC, implemented a new rule regarding the use of consumer reviews and testimonials. Can we go to the next slide, please? It will take effect on October. But I think a lot of businesses may want to take a step back and realize that there's a few things they're doing that aren't quite right, or they need to do a few more things just to ensure transparency. I say that there shouldn't be any major changes because the FTC Act already declares unfair and deceptive practices in commerce to be unlawful. This rule is simply spelling out which practices regarding consumer reviews specifically are unlawful. And now the FTC is going to be enforcing these prohibitions that I will discuss in a little bit with fines up to $51,000 per violation. So that would definitely add up quickly if you are in violation. Let's go to the next slide, please. The problem with fake reviews. For those of you who don't know, the FTC is tasked with protecting consumers and protecting fair competition. With every single report indicating consumers are relying on reviews, whether it's they're shopping online, they're choosing a restaurant, a hotel, and even now when they go into brick and mortar stores, they're pulling out their cell phones and they are checking the reviews before they decide to make that purchase. With this reliance on reviews, you can imagine there's a simultaneous growth of the misuse of reviews, and that's what the FTC is looking at. This problem is so rampant that all of the big players have been addressing it for a while now. So Google has reported that in 1 year alone, they had to remove 115 million reviews because it violated policy or they were fake. Similarly, TripAdvisor has to repeatedly take down reviews, noting that many of them are taken down before they're even posted. And then afterward, if they are posted and they determine them to be fake, they are removed as well. So with all of the big players, applauding this, the FTC now has some ability to enforce this as well. The big players support it. It's great for consumers. I mean, it's great for us in our personal shopping lives. But on the other hand, I believe this rule necessitates some smaller businesses who rely on reviews for SEO and growing their business to reevaluate their strategy when it comes to one, procuring reviews, and two, how they manage these reviews. So on the next slide, I'm going to break down the specifics of this new FTC rule so we can discuss some good and bad practices when it comes to social media and review management. All right, so this rule can kind of be summarized into 6 unlawful practices. There might be 1 or 2 more that you kind of comb out of this, but we'll boil it down to 6. Those are being fake reviews, the practice of buying and giving incentives for reviews and when they're conditioned on how the review goes, reviews by company insiders, the creation of a separate company controlled website to either promote yourself or give reviews that are negative to your competitors, the suppression of negative reviews or the display of your positive reviews in a misleading fashion, and the misuse of social media indicators. So let me break down each of these so you kind of get an idea of what some good practices and bad practices are. This new rule really goes into detail on what all of these mean. Starting off with fake reviews, the rule defines a fake review as anything that misrepresents the experiences of reviewers or testimonials. So as you can imagine, that's very broad, anything that misrepresents it. The rule also includes that posting AI generated reviews and passing them off as real reviews is definitely misleading. This would be different than what Amazon does when you see a compilation, an AI generated compilation of all of the reviews. One that is clearly disclosed that it's an AI generated compilation, and so consumers are not viewing that as an actual, consumer review. But if you are just making up reviews or paying companies on the other side of the globe to just put reviews down or make reviews that are impacting your competitors, those will be considered fake, and the FTC will find that a violation. The next prohibition, which involves the buying and giving of incentives for reviews, is probably the practice that is going to have to be changed most because of this rule. And I say that because we've all seen different promotions or emails that are $5 for a 5-star review, where a business is asking you to leave us a good review and we'll give you a coupon or a discount of some sort. The FTC is now saying, hey, this is misleading, do not do this. It's one thing to solicit reviews, to remind your customers, hey, reviews really help us, please leave us a review, but you cannot sway whether it's going to be a good review or a bad review. And just like the fake review definition is really broad, the definition of what an incentive is also very broad in this. So it includes discounts, coupons, even contest entries. If you are giving something to someone for a review and saying it has to be a positive review, it's going to be found to be a violation of this. And that also will correspond to the other prohibitions that I'm going through about whenever you are paying for any testimony, any endorsement, any link needs to be disclosed. So that goes into our next prohibition on company insiders and relatives leaving reviews. Like I said, any link between an endorser and the business needs to be disclosed. This rule goes as far to say that you can't hide behind your relatives and just say, hey, look at this outside review that's so positive for our product. It's still going to be considered an insider review. And if you are paying for endorsements, disclosures must be made. And there are also specific rules about how these disclosures are advertised. It's not enough to just say ad or put it in small text. It needs to be clear and conspicuous. And there's lots of details about what, depending on the platform and how you can make that disclosure clear and conspicuous. The next prohibition regards having an independent website that truly isn't independent and deceiving people into thinking that a third party, another source has been reviewing your product, your services, or on the other hand, negatively reviewing your competitors to make you look better. This is not going to fly now. And again, any link between an endorser and the business needs to be disclosed. So you cannot hide behind a company controlled website and call it an independent website. And then the next one has to do with negative reviews, suppressing them. And this will come up when companies are displaying their positive reviews in one place and making it seem like there are no negative reviews, or they have all of their 5-star reviews on the front pages and their 1-star reviews are all hidden in the back. Just like you shouldn't be buying positive reviews, you should not be threatening consumers who leave negative reviews with any legal or physical threats. And if you are taking down any reviews, it needs to be consistent. So this rule does allow for negative reviews, well, negative or positive reviews to be taken down if they violate your policies. So, for example, if they have profanity, if they're harassing or really vulgar in any way, you can remove them, but that would also mean you have to remove any positive review that contains profanity or any such content. And then lastly, the sale and misuse of false indicators on social media. This comes down to buying likes, buying impressions, views, followers. You can't be paying a company across the globe to view your product, put it in their carts, and then say, look how popular this product is. That's just not going to fly under this new rule. And people are going to have to be careful when they're using their social media and their followers to promote commerce. So again, this rule just boils down to being fair and transparent. And if you have any questions about the different types of reviews or the disclosure language needed, feel free to reach out. Thank you.
Alyssa, thank you very much. I see why you thought this would be an interesting topic, and it is certainly informative. And as you pointed out, it is something that each of us has encountered in the day-to-day. If you do any shopping online or elsewhere, you've seen what it is to have reviews exchanged and the various ways that can be done in an encouraging way versus a coercive way, as just some of the issues you brought up. So please come on back with more content, whether updates on this or any other presentation that you may have. We'd love to hear from you. Sophie, if you wouldn't mind, please advancing. There are a couple more items I want to make sure we cover. Next slide, please, after that. So as we close today's program, I wanted to remind all of you of a programming series that Bond is putting forth that is happening around New York State. It's the pregnant worker, what to expect when an employee is expecting. It's the labor and employment fall 2024 breakfast briefing. There are dates arrayed throughout September and October, and we hope that you find the presentation that best aligns with your location and availability. If you have any question at all about how to register, you can click through bsk.com/events or just please contact me. And otherwise, I wanted to remind all of you that if Sophie, you would go to the next slide, please. you can contact any of the presenters from today, including Kamisha, Christy, Sam, Alyssa, or if you need me, it's goberfield at bsk.com. And I also want to remind all of you that we have sexual harassment prevention training available. I've talked about that before. It's a great resource. We can right size it to your organization. Don't hesitate to ask because we want to make sure that we get that resource to you if you're in need of it. And the essential guide on employment law is also something we're proud to make available. So you can look for that as well. And I will be back with you next week. Kristen and I juggled a little bit on hosting duties as we wrapped up August into September. So Kristen had the last 2 weeks and I have this week as well next. I'm delighted to be back with you on the 17th. And in the meanwhile, feel free to reach out to me if anything comes up. Otherwise, looking forward to presenting on what is new and topical in a week's time. In the meanwhile, have a terrific afternoon and thank you for your loyalty to the program.